car crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with the attorneys of Hollis, Wright.
Hello, I'm Mark Franklin. We want to welcome you to the attorneys. Good to have you with us once again. And we're going to be talking about landlord-tenant laws. Know your rights. We've got a great guest lined up to help you understand that. Also want to remind you that you can get in contact with one of the lawyers from Hollis Wright right now. All you have to do is dial 1-844-LAW-TALK, and that call is confidential. That call is also free. Someone standing by to take that call for you right now. Josh Wright is here, of course, and we've got a special guest. Andrea Neely is with us as well. So, Josh, this is one we really have a lot of people waiting to get some information about.
Well, not just that, and one of the statistics that I think is important is roughly 40% of people are leasing or renting for their way to live. And so you think about that, that is a huge portion of the public that this show could impact. And there are ways that you can do this smoothly with landlords, and there are ways that you can do it not so smoothly with landlords. We're going to be talking about all those things today and kind of unwrapping this topic. We're really excited to have you on, first of all, so thank you for being here.
Thank you so much for having me.
How did you get into this area of the law? This is not a area of the law that every lawyer can get into and understand. It's complicated. You got to know the law. How did you kind of get into this area?
Well, about 2019, so I'm fairly recent to this area of the law. About 2019, a friend of mine called, and her daughter is a landlord and needed some help with an issue. So I've been on both sides of it. I've helped landlords with problematic tenants, and I've helped tenants since that time with problematic landlords.
Does Alabama have kind of the, if you will, the Bible of landlord-tenant in Alabama? Is there a rule? Is there a statute that applies to kind of what the rights and responsibilities are? Yes,
sir. Here in Alabama, we have the Alabama Uniform Residential Landlord and Tenant Act. That act came into effect in 2007, but before then there was no codification of the landlord and tenant relationship. So that's fairly recent too when you're thinking about 2007.
So the statistic I mentioned, I think it was actually 37% of individuals lease or rent their homes or apartments. That's a big number of people, right? I mean, that's a huge part of society.
Exactly. That is a substantial number of people. And so lots of people are affected. If you're not a renter, maybe you was one as a student if you went to college, or you know somebody who rents. So it affects nearly everyone.
Yeah, this show will be perfect for that.
And in your practice, do you find yourself dealing more with the tenants or more with landlords when you talk about a number that high?
Actually, it's been pretty even, to be perfectly honest. There are some really good tenants out there. I rented for a very long time, and I was a good tenant, and I had some good landlords. So there's some good people and some bad people on both sides. And I think a lot of times it just falls down to misunderstandings. I don't think anybody or few people come to the situation being deliberately on the wrong side of things.
And certainly becoming, when you're a student, many of us were renters as well, or leasing. The key there, I think, is making sure you treat the property as if it's your own.
Exactly. Treat it like it's your own, and from a landlord perspective, to treat the person like their family, to seek an understanding and seek some middle ground. I haven't had a lot of huge blow-up situations. Again, a lot of these things are misunderstandings and can be smoothed over pretty quickly. It doesn't often go to court, but it can.
Talk in general terms about kind of how a lease or a leasehold is set up. What exactly is the lease, and what should you be looking for if you're looking to potentially go sign a lease agreement?
Well, a lease, in a word, is just a contract, and it's a contract between the landlord who owns the property and the tenant who needs to live there, but is not buying it. And so when you're looking to lease a property, what you want to look for is Well, you want to read the entire thing, but they can get pretty lengthy. What you're looking for in the lease, though, are the things that maybe affect your money. So you want to know the amount of the security deposit, you want to know the amount of the rent, you want to know if the rent is inclusive of some other thing like the water or the cable, or if those will be separate. You want to know who and how you pay the rent. Nowadays, we can pay rent online, but some places won't accept online payments. And you want to know when the rent is due and when is it considered late. In terms of not financial things, you want to know the lease term. How long is this contract? You want to know when can the property be available for you to move in, and how to report a repair issue.
You know, a lot of times what we will get is a call from someone, and we send them to experts like this. But it will be hey, I have, 18 months left on my lease. I signed a 2-year lease. I want out. What do I do? And a lot of times it's as simple as looking at the lease agreement to determine what the rights and obligations are. And that's right, isn't it? That
Absolutely.
Ultimately the tenants and the landlords in the lease agreement itself, they have certain obligations and responsibilities they got to follow.
That's exactly right. That's exactly right. If you just have to leave, it really depends on what becomes most relevant if you're going to cut your lease short is why. Because it is a binding contract, and honestly, the landlord can hold you responsible or accountable to the entirety of the contract. But there are extenuating circumstances. So if you have a situation like you're in the military and it's a military deployment, then you're very likely to be able to get out of that. That's governed by law as well. But if it's a situation where you got a new job, even though that's important too, the landlord doesn't have to let you out. It's discretionary to the landlord. You can look into an option like subletting, but the act that we talked about, the Alabama Uniform Landlord-Tenant Law, that doesn't cover subletting, so it's discretionary to your landlord.
Do you find that people that get sideways with their landlord leave the leasehold and stop paying rent, it can impact their credit moving forward?
Absolutely, absolutely, because it puts you, breaching the contract is just like breaching the contract in any other legal situation. It subjects you to the penalty of a breach of contract claim in court. And once you get that judgment against you, you have that impacting your credit, and then you're on the hook for the damages that stem from that. They have to get the property ready to lease it again. And so it can turn into a really big deal for someone who just drops the lease and leaves.
Getting a lawyer involved early prevents you from having these headaches down the road for sure.
Right. There's so much that we really have to unpack with this, whether you are a tenant or whether you are a landlord, and we've got the right person here to do that. So we want you to just put a pin right there. We're going to take a break because we've got some other things that we want to do. We want to make sure that we let you know that you can get in contact with a lawyer from Hollis Wright by calling 1-844 Law Talk. They're waiting to hear from you, so make that call. You can do that while we're in this break. That call will be free and it will be confidential as well. Andrea Neely is here, and we're talking about landlord tenant laws so that you can know your rights, giving you the information that you need. We're going to take a break. We'll be back and make sure we get your questions as well.
I'm Josh Wright with the law firm of Hollis Wright, a personal injury law firm, and thank you for watching The Attorneys. We hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple: to provide answers and legal counsel when you need it the most. Your call to the show is free and off air. So if you have questions specific to the show or related to other accident or injury topics, call, email, or text us. You can also follow us on Facebook, Twitter, Instagram, and YouTube, or go to hollis-wright.com and click on the Contact Us button. We know your time is valuable, so thank you for spending it with us and watching The Attorneys.
The Attorneys, proudly sponsored by the law firm of Hollis Wright, are here to serve you.
When we started the show 8 years ago, my hope was we would be able to do what we do best, which is to help people answer real-world legal-related issues they have in their life.
People oftentimes are confronting various legal issues and problems in their lives that range across the gamut of legal practice areas. Bankruptcy, criminal law, family law, just to name a few. And to be able to have a 30-minute platform or format to where we can just cover various legal topics once a week, that's obviously the primary focus of the show.
That we would be able to use the resources of the many lawyers we have at this law firm to create a plan that had a lasting impact that also gave back to the community at the same time. And I think we've done just that with the attorneys. We love this state and its great people. People that are worth fighting for in their lowest moments. It's what drives our lawyers to do what we do. We're here right now to fight for you. At Hollis Wright, your result matters.
Welcome back to the attorneys as we are talking about landlord-tenant laws. Know your rights. It is a great discussion. Something else we love here on the attorneys are those questions that we get from you. As we come back to Andrea Neely, thanks so much for being with us as we get back to some of the questions here. This is one I want you to tackle for me. I am currently apartment shopping. What advice can you give me prior to signing a lease?
Prior to signing a lease, I recommend seeing the property in person. I recommend going there and doing a walkthrough with the landlord or the property manager, somebody with some authority to let you in and see the actual apartment that you will be renting, the apartment that's up for lease. See that actual place. Here is where you get to be nitpicky about the details. Look for the big details, of course. You want to make sure that there's running water. You want to make sure that there are no electrical hazards, no loose wires. You want to make sure that if the apartment provides appliances like a stove, a refrigerator, a dishwasher, you want to make sure those things are working. But look for the small things too that don't affect habitability, those defects that you can live with, but you still need to make note of. So look for cracks in the walls, look for holes in the walls, look for warping in the flooring. And the reason why you want to nitpick on this issue is at the end of the lease, when you move out, you don't want there to be any confusion about who or how these issues were caused. And the good thing about today, the times that we're living in, is that we all have camera phones at our disposal. So take pictures and memorialize the apartment as it was prior to you moving in, and then talk to the apartment, the landlord, about how and when you can expect them to make those repairs.
Yeah, and I was going to ask that, as it relates to repairs before you move in, that's a little bit more clear cut. Let's assume that there are repairs that are necessary after you're already there, though. Are those repairs generally covered by the landlord, or are there certain things that you're going to be responsible for?
Well, major repairs and replacements are typically covered by the landlord. So if you have a leak from the roof or something like that, that's definitely a landlord issue. But if you have something minor like a battery replacement or a light bulb replacement, that's typically something that the tenant is expected to handle.
I see and have in my practice a lot, unfortunately, fire-related injuries inside an apartment. And the significant issue in all of those cases, and I'm sure you've seen this before, is who is responsible for the maintenance and service on the batteries and the fire detectors and in the smoke detectors. And that is an issue that I would highly recommend that you understand in your lease to know, so that you don't put yourself in danger and don't have a smoke detector that's working because you assume your landlord's going to come in and fix it. Your lease agreement generally is going to cover that, but it's critically important to make sure you protect yourself.
Yeah, you were talking about nitpicking on the front end. Once you get there, you really have to understand the things that are in the lease like that, so that you do know what you have to do as a tenant and what the landlord can actually take care of.
Absolutely. And you don't want to let the lease intimidate you, but they can be big. And so by way of an exhibit, I brought one, an old lease of mine, and look at this guy.
It said like 25 pages long?
At least. It's about 26. That was a good guess. And so, yes, they can be pretty overwhelming. You just have to take your time on signing day and read it and keep a copy of it for your records. Don't just discard it. I know as an attorney, when I get those calls, my first question is usually, where is your copy of the lease? And read it to me, especially if we're talking over the phone.
I have and this is a question I have for you. I have a client, walked into her apartment and I felt like there were some conditions that needed to be fixed. And I was like, why have you not talked to your landlord about this? He is responsible for fixing these. She said, I don't want to be kicked out. I don't want to not be able to stay in this apartment. And I said, well, ma'am, that's not how it works in the law. The law is going to protect you in that circumstance. Can you talk a little bit about that? I mean, just because you're complaining about something that needs to be fixed, your landlord can't kick you out.
Absolutely not. Retaliatory conduct like that is absolutely unlawful. Once you sign your lease and you lock in that rental rate, that becomes binding on the landlord. So if something later comes up that needs to be repaired, even if it's an expensive repair, that's the landlord's responsibility, and they cannot and should not kick you out or increase your rent over a repair issue.
Do you find that having the right temperament as a tenant with your landlord is important to maintain that relationship, to just be able to, if you will, kind of win tip balls as necessary? I mean, is that temperament, does it matter?
I think it does. I think that you get more flies with honey, right, than with vinegar. And you have this. I like
that. I'm going to use that.
And you have this lease agreement that is binding on everybody. So I do think that temperament counts. Maybe that's the southern lady in me that believes in manners and treating people fairly. But absolutely, why not call your landlord and recognize that they're human too, but do it in the right spirit. Definitely call them. But I think we can turn people off if we're constantly, yelling and being unpleasant as we do so.
You've got that big lease there as an example with 26 pages there. Are there clauses that the landlord cannot put in that lease?
Right. The landlord is bound by the act just like the tenant is. And so the landlord has absolute obligations that she cannot contract away. So she cannot contract away her obligation to provide a habitable place, a place that's fit for people to live in. She cannot contract away her obligation to make sure that there's running water, that there's proper and functioning indoor plumbing and electrical. She can't structure the contract in a way that she makes all of the repairs the tenant's responsibility. So if we get to a situation where there's some confusion that has to go before a judge and you find one of these bad clauses in a contract, what a court can do with an unenforceable clause is just kind of strike it out and ignore it and leave the rest of the contract, if it's fine, if it's enforceable, leave that intact.
I know we're getting ready to go to break. When we come back, I want to talk just a little bit about kind of trends and things that are seen in this industry, and just kind of go through that. Maybe it can help some people watching.
Yep, Andrea, really helping so far. Good information. Want to remind you, though, we love your questions as well. In fact, we're going to take a break, but on the other side of this break, we're going to hear from one of our viewers. We've got one of our video questions from our viewer that we're going to tackle as we continue here on The Attorneys. Stay with us. We will be right back.
I'm attorney Bobby Bell with Hollis, Wright Law Firm. In today's world, social media is all around us. It is common for many people to post on social media regarding their life and activities on a daily basis. Facebook, Instagram, Twitter, and similar social media are a great way to stay connected to others and to share your experiences and thoughts. Some seemingly innocent social media posts, however, can have devastating effects if you're involved in litigation, especially in a personal injury claim, a contested divorce, or a child custody battle. Courts regularly allow adverse parties access to the other side's social media accounts, allowing relevant posts to be presented as evidence. These rules have allowed social media to become a hotbed of information in the litigation world. In fact, we are seeing more and more preservation orders issued by courts requiring you to collect and save any and all social media activity. Therefore, it's advisable that even before there's litigation, lawyers should advise their clients that social media content may be discoverable. Here are a few helpful tips. 1. Do not post anything about the case. This includes posts regarding conversations or meetings with your attorneys, remarks about your injuries, negative remarks about the opposing party. Do not post anything you would not want read in open court to either a judge or a jury. 2. Avoid new friend requests from people you do not know. Many law firms and insurance offices may attempt to have employees follow you on social media and attempt to gain information. 3. Limit adding new photos, check-ins, photo tagging, etc. Seemingly innocent posts may be used against you. Regular check-ins at restaurants, parties, or other events with friends can cast doubt on any claims of loss of enjoyment of life, pain and suffering, or emotional distress, since you appear to be living life as usual. 4. Increase your privacy settings. Many social media sites frequently update and change their privacy settings. In the litigation context, it is possible you may have to preserve and present anything you posted. Therefore, we encourage you to be smart and careful when using social media. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and promise to you. Thanks for watching The Attorneys.
You see us each Sunday night on The Attorneys, but remember, our attorneys are here all week long to help you with your personal injury claim. Our attorneys are standing by right now to give you a free consultation at Hollis Wright. Your result matters.
Landlord-tenant laws, know your rights. That is a topic on today's The Attorneys. We're so glad you can join us. We love hearing from you. In fact, Josh and Andrea, as we come back, we have a video question from one of our viewers. This question is from Sarah, so watch this.
Can I stop paying rent on my apartment if my landlord fails to fix a leak in my roof?
So Sarah, thank you for that question. That's a good question, Josh.
Yeah, and I'm going to let you handle it since you're the expert in this area. And it actually plays into a question that I was going to ask you in this final segment too, but go ahead.
Okay. Well, the short answer is no. Okay. You cannot withhold rent for a repair issue to force a landlord to make an issue. Withholding rents is a breach of the contract. So what you do instead of withholding rents is you take a look at the lease to see if the repair issue is addressed directly by the lease. If it is, then you use the lease as your proof, your leverage to get that repair done. If the specific repair issue is not covered by the lease, but it is necessary, it goes towards habitability. So the leak in the roof goes towards habitability. You put that in writing and demand that the repairs are made. The landlord by law has 14 days to fix a repair issue. If in those 14 days it is not repaired, the tenant can then move and terminate the lease. If the tenant has to move by reason of a disrepair, then the tenant can later sue for damages, including the cost of the relocation.
So that's a great answer. I was going to actually ask this question, which is, are there other things that could make a apartment uninhabitable where the person would have the ability to make a request and then ultimately depart if it wasn't fixed, other than leaks? And it sounds like what kind of falls under that category is what I'm getting at of what makes something uninhabitable?
The lack of running water,
okay.
The lack of hot water, poor or dangerous electrical. So if you have flickering lights and it's not the light bulb, that's a fire hazard. So those things, the inability to shut and close doors and windows, because then if you're if you can't get out,
Yeah.
that's those things that go to health and safety.
Okay.
They affect habitability.
Talk about just generally mold. I know you get a lot of these calls. We
do.
get a lot of these calls
I do.
too. They're now coming to you, by the way, because I'm not quite sure how to answer those. That's not because it's not something that is within the skill set of what we do. So we generally do send these out to people that are experts like you. How do you handle that from a mold perspective? Like, are there certain molds that make it uninhabitable, some molds that aren't? Do you have to have it tested? Like, how does that work in general terms?
Mold cases can be pretty involved. It's not a situation where as soon as you see mold, you can immediately vacate, because not all molds are dangerous.
That's right.
So what a tenant has to then do is see a doctor and get tested, and you have to have that medical proof that whatever your condition is caused by this mold.
Okay.
And then that kind of sets the stage for the further action of leaving or terminating the lease.
I want to get to another question. Unfortunately, these come up. This situation will come up from time to time. This question says, I have received an eviction notice. What does this mean, and what do I have to do?
Okay, so if you actually, once you get the eviction notice in hand, and you're going to get that from the sheriff or a special process server, the landlord will not serve you an eviction notice. So once the sheriff comes to your door and gives you an eviction notice, that's when the clock starts running. You have 7 days to file an answer. And so you really should talk to an attorney. A lot of people surprisingly try to handle these on their own. They neglect to answer in time, and then everything goes haywire. They get a default judgment entered against them, they get evicted. So once you get that eviction notice in your hand, you have 7 days to file an answer. If you don't file an answer within those 7 days, then the landlord can then go ahead and ask the court for a default judgment. If the default judgment is entered against you, then you run the risk of being forcibly removed, yourself and your things, by the sheriff.
What do you recommend at the end of your lease? Let's say everything went smooth, but you are going to move out and you're coming to the end of your lease. Are there some things that you need to do to make sure you kind of document things, protect things, so that you can leave and depart without being responsible for paying for wear and tear, that kind of thing?
Right. 2 things. You have to give your landlord a proper notice, and you have to clean the place up. And so the amount of notice that is necessary is usually codified in the lease. So some places want 45 or 60 days. But if the lease doesn't address the issue, a good rule of thumb is 30 days. Okay. You also need to clean up. So clean the refrigerator, clean the stove, make sure that the place looks as close as possible to what it looked like when you rented it. Is to put it back in the condition that it was in. After that, you can be assured, or almost assured, of getting the full amount of your security deposit back.
This is a good reason why, when you're ending a lease, you want to make sure that you are communicating with your landlord. Very important. Right. Great job today. Thank you for being on. We appreciate you.
Thank you for having me.
Absolutely.
Neely, thank you so much. Josh, thank you too. And thank you for watching at home. And make sure you catch us next week, same place, same time, for another edition of The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.